learned brother said that more than 180 days. They envisaged as a committal for their release, before their release. My Lord, your learned brother also gave guidance in finding but even in determining the conditions those conditions, the court only has to deal with questions we only have to deal with one question, whether the applicant will abscond. But my Lord, in their affidavit in response, the state raised objections which are point quickly, because most of the points have been covered. But in pointing them out and responding in our submissions in regard to those objections, we are mindful of the test set by the Constitutional Court in the Kizza Besigye reference and the Foundation for Human Rights petition, and all those decisions by your brother judges and sister judges, where they have stated that mere assertions are only speculative and cannot remove the right which is guaranteed by the Constitution, which has matured as has been the case in the matter before this court. Now, the court raised the objection in paragraph 7 of the effective effect of police to conduct a procedure question. Their first objection was that the applicants are not law-abiding. Because the charges against them emanate from participation in unlawful activity. And my Lord, the objection, if at all it is merely that statement, that they are not law-abiding because the charges emanate from participation in unlawful activity. There is no explanation whatsoever, or there is no effort to explain or to put in a little more detail what the unlawful activity. They don't state when those unlawful activities took place, where they took place, or when they took place, or the level of participation of the applicants. And all it is such statements which might rather warn the court mere assertions which are speculated, and which fall far, far short of removing the entitlement regulatory. Again, my lords, in the Kizza Besigye reference 20 of 2005, the Constitutional Court pronounced itself that the constitutional dispensation in Uganda is that an accused person is presumed innocent until they are proven guilty. So in a scenario where the court has not pronounced itself on the activities and whether they are unlawful, it is not safe for the court to take that as a valid objection. My lord, again in Kavuma Hassan versus Uganda, which we referred to, it was exactly the same objection. Unlawful activity. The learned brother, the Honorable Justice Mwaka, found that that statement was a mere assertion which had to be disregarded. And that was a case where Mr. Kavuma had 8 charges of aggravated robbery. The court disregarded those statements. My lord, the second objection by the state is in paragraph 5 of the affidavit in response. Sorry, I beg your pardon, paragraph T, the objections are the same for the trial. Where the state says that the accused persons have not spent 180 days on remand. The state, however, admits that they have spent only 168 days. My lord, they make the calculation. The state contains that there are 168. 68. They calculate from 21st February 2025 up to date, perhaps. I know we have submitted the case of Mwesike, where your land brother, in curing the lacuna caused by the Honorable Kabaziguruka petition, they appealed that petition for charges which stem from the General Court Martial. And also referring to the Aaron Kizza application, that the court must intervene where there is such a lacuna. But it's not the making of the applicants, that the state pursued a course of action that was deemed unconstitutional. by the Supreme Court. The Africans are merely victims of that unconstitutional order. So that the Supreme Court made a pronouncement the state wants to argue that those days when on remand is brushed aside. That is wrong. And those points were covered by the Honorable Justice Mwata in page 3 to 5 of his ruling. Say that in matters of that nature, the court must invoke its inherent power to grant the accused bail. And that matters of bail applications in those cases my lord, the court was emphatic and grounded this decision of use in Article 126(2)(e) of the Constitution, that it administers justice without undue regard to technicalities. So, my lord, the lacuna caused by the pronouncement of the Supreme Court which impacted on the charges before the General Court Martial and the remand there, cannot be visited against the rights of the Africans. As victims of the process, they are entitled to take benefit. That's where the court comes in. Because it's the custodian of justice. My lord, criminal prosecution is such that all the resources of the state focus on an individual. In this case, the two individuals before your lordship. So that any breaches of the law of the state cannot be the fault of the applicant. And the state cannot be allowed to take benefit at the expense of the applicant. That was the view of the Ghana draft. And my lord, we are mindful of the fact that in this case there was a transfer. And that transfer is admitted in the affidavit to reply. However, it would be absurd for the state to argue that it took over everything about the prosecution except their remand. That's absurd. So who remanded them? They were in a government facility. And my lord, BIP Kukundakwe accepts my lord, in their affidavit, I just want to emphasize that. My lord, in paragraph 5, paragraph 11 in particular, from paragraph 10, if I may read it, the first applicant, and in his evidence, he does take for himself an example of the second applicant, and on the 31st of January 2025, the Supreme Court of Uganda delivered judgment in the Constitutional Appeal number 2 of 2021, Attorney General vs. Economic Kabaziruka, inter alia, that all trial of civilians before the General Court Martial was unconstitutional. In paragraph 11, that because of the Supreme Court judgment, we were not produced before the General Court Martial on the 3rd of February, and were remanded in prison without any lawful remand warrants or charges. And my Lord, in response, which is in paragraph 10 of the affidavit of Okunda, that is an affidavit in reply to the first applicant's affidavit. It says in paragraph 9, the contents of paragraph 6, 8, 9, and 11, my Lord, 11, which speaks to their being remanded without lawful warrants in the government prison. Mr. Kundakwe says that the contents in the applicant's affidavit are admitted to the extent of the charges against the first applicant, his appearance before the General Court Martial, his appearance before the General Court Martial, and remand. So it admitted that they will remand. That position is also the same in his response to the affidavit of the second applicant. And in regard to the second applicant, Mr. Kukunda affirms in paragraph 7, he admits the charges against the applicant, his appearance in the court martial, and his remarks. So, my Lord, to the extent that the people admit that they want to remand, and they stayed on remand, the court should cure the lacuna. And you should be mindful of the fact that there has been no break whatsoever from the events that unfolded in the General Court Martial. It has been a continuous process of remand after remand after remand, with not a second of liberty in between. So we invite the court to invoke its powers, Article 126, Rising Justice, 139(1) of the Constitution, Section 17 of the Dictator Act, to cure that lacuna, to prevent an abuse of justice. It cannot be this court to argue that the remand between November 2024 and February 2025 was no remand. The court cannot aid the state to commit wrong. if it is the same state, under the veil of the general court martial, which manifested in the power magistrates court. The consistency is the remand, and perhaps the argument. My Lord, be that the case, in the alternative and without prejudice to what we have said, in the unlikely event that the court should agree with the state that the 180 days should start from the charges at Macau, I don't say unlikely, because the court cannot ignore the fact that the applicants have been in custody since November. But on the fallback position is found in the judgment of the court of the Constitutional Court in what we call the Kizza Besigye reference, number 20 of 2005. Number 20 of 2005, Uganda APP versus Canon retired Dr. Kizza Besigye. By noting that decision, and which was reaffirmed in the constitutional petition number 20 of 2006, the court found that still under Article 23(6)(c), 23(6)(c), an accused person triable only by the High Court, triable by offense, charged with offenses tried only by the High Court, and who has not spent 180 days on remand can seek release on bail. And in that case, the court has the discretion to grant or not to grant bail if they fail to show exceptional circumstances. My Lord, the court found that that is the import, that is the only reason, that is one of the reasons, I beg your pardon, why there was amendment number, why there is a Trial on Indictment Amendment Act, number 9 of 1990. I know that is the rationale for the Trial on Indictment Amendments Act number 9 of 1998. My Lord, the court argued that in such a case where the applicant comes to court through this article, the court does not consider the conditions for ordinary bail. It only refuses to grant bail on discretion if the accused or the applicant fails to show or satisfy the court about or regarding the excessive circumstances. My Lord, for brevity, one of the exceptional circumstances is age or advanced age. My Lord, in the affidavit in reply of Ukundako, BIP, both in regard to the first applicant and the second applicant, he admits that both applicants are of advanced age. My Lord, as we close, and I close, sorry, not we, I close, because my colleague may want to add. The other objection has been in paragraph 20 and 22, that the accused will abscond from bail. Such plain statement was the case in the constitutional reference 205 and the Usinge Stephen case. Again, it was a statement that the accused would abscond because of the gravity of the offenses. My Lord, the court in that case found that that too was a plain statement, perhaps because the state was not expected to change. My Lord, we are mindful of the fact and has been shown in group annex F of the first applicant's affidavit support. They have been charged several treason, treason, terrorism, rape, etc. and has not failed to meet any condition, because in all those cases when we do. My Lord, in paragraph 23 of the affidavit in reply, because they are the two, they are more or less the same. DIP Ukundane states that in the prison trial against the first applicant and whose predecessor he absconded. I don't think that abscond must be a finding of court in order to show that there was an abscond. But my Lord, as shown in the affidavit in rejoinder, that is not true. Sureties were never penalized, and in fact those charges were withdrawn. My Lord, the impressive aspect that in that allegation or statement, the state supports that with an equalist record. My Lord, to the extent that we are alive, we know that equalists were not there in 2017. Where the state is getting this truth, we don't know. But that is the state. objection in paragraph 26 regarding the sureties. My colleagues will allude to that same time that your learned sister, the Honorable Justice Kanya, in application 133 of 2025, found all the sureties substantial according to statute. And there is any, the state has not shown that there is any change regarding those sureties. Another objection in paragraph 27, which speaks to investigations. We are aware that there has been a commitment for an investigation. There are no investigations in that field. The other objection is in paragraph 28 and 29 regarding witnesses in Uganda, Kenya, Switzerland, and Greece. And that the applicants have associates in these countries. It is the same unsubstantiated allegation which the court in Kizza Besigye said should be disregarded. The associates are not there. And in the indictment, there was nothing to show that there was evidence from these countries. Now, in paragraph 30, the state contends that the followers of the applicants are violent. They threaten the court, they sing loudly, they hold press conferences, the benefit you have today is that, my Lord, you are present. You didn't hear any hymns or songs for that matter. And we don't want to take the view that your Lordship was scared or under attack. So, my Lord, we submit that the applicants have satisfied the requirement to be entitled to get this question. Lastly, my Lord, as I wind up my submission, as indeed the Constitution commands, this application was made in the lower court because the lower court is enjoined. And the power of the lower courts to do so have been the subject of court's findings by your learned brother, as he then was, the Honorable Mr. Justice FMS Gonantende, in Uganda versus Tesimana Rosemary, Massacre Criminal Revision 13 of 1999, Uganda versus Tesimana Rosemary, Criminal Revisional Course in Massacre, number 13 of 1999, Criminal Revisional Course, number 13 of 1999. And again, the Honorable Mr. Justice FMS Gonantende, and then was in Criminal Revisional Course Massacre number 5 of 1999. That one is Shabuhuria Makia versus My Lord, the court, the High Court, informed the lower court that it had power to intervene in delays of this nature to avert the miscarriage of justice. What we have seen, my Lord, is that the lower courts have been shy or meek or timid to do the right thing. So, my Lord, it is a breath of fresh air that we are before a High Court, which we believe will not be shy, will not be timid, and will not act under any influence, as the learned brothers found in the Kizza Besigye matter. We invite court, my Lord, to invoke the bold spirit and not be timorous, so that an abuse of process and a miscarriage of justice is averted. My Lord, I'm closing. I just want to make a final remark. My colleagues have just changed my approach. My Lord, we refer, my Lord, to a land author, Lord Alfred Thompson Benny, in his publication, The Discipline of Law, London, 1979, at page 315. My Lord, if I may quote, if I conclude my remarks. Say that if the powerful still abuse their powers without restraint, if the powerful still abuse their powers without restraint, it is thanks to the dominant influence of timorous souls. It is thanks to the dominant influence of timorous souls. Semicolon. Bold spirits will not let that stand. Bold spirits will not let any rule of law. Bold spirit will not let stand any rule of law which impairs the doing of justice. They will do all they legitimately can do to avoid that rule. Even change it so as to do justice in the instant case. My Lord, it's a prayer of my colleagues now that the court will adopt, unlike the courts below, a bold spirit so that justice is done in the matter before. I call it not.
My Lord, I can address you in two specific areas, or other issues. The first one is about the spirit of mandatory. The spirit of Article 26, rather Article 23, sub-Article 26, Article C. My Lord, I make reference to a number of authorities that have brought out Article 23, 23, the spirit, my Lord, the protection and safeguard the sanctity of the right, liberty, as well as guarding against abuse of the court process. My Lord, I will refer you to the decision of the senior Stephen, miscellaneous application number 021 of 2025, a very recent one. My Lord, July to be exact, like Justice Flavia, 30th July 2025, and my Lord, on page 4 of that decision, your sister had this to say. Being under Article 23(6)(c) of the Constitution was introduced as a safeguard to prevent the state from keeping accused persons in prison indefinitely without trial, particularly where the committal process has been delayed. The court is therefore required to strike a balance between the applicant's right to liberty and presumption of innocence and the public interest in ensuring that those charged with criminal offences are brought to justice. And she concluded by saying, in doing so, the court should impose conditions that are fair, reasonable, allowing the accused to enjoy the benefit of mandatory bail, while also making it possible to ensure that the accused continues to attend court as required and to be test. So the point here, my Lord, is that the right to bail under Article 23 is meant to guarantee enjoyment of the right to liberty and also safeguard the processes of this honorable court. The same decision is reflected, my Lord, or rather reinforced in the authority of Afro Henry. We have our bundle of authorities, my Lord. Afro Henry is criminal miscellaneous application number 096 of 2025. My Lord, in this decision,
My Lord, we don't have those bundles my colleague is referring to, but if it's saying they have such.
my Lord, they are only things, but for the benefit of the state, I can offer them a copy. But they are there on the APP. My Lord, this is a reinforcement of the earlier decision cited by my friend here, Mpanga, the one of Justice Mwat. Now, this one, my Lord, is about, again, Article 23, where His Lordship said, after reviewing the affidavit evidence and the applicant's submission, this court finds that the applicant was detained on remand for over 6 months without committal to the High Court for trial exceeding the mandatory procedural timeline. The subsequent committal occurring only after this period lapsed must be weighed in the applicant's favor, particularly in the context of any relief sought, as bail to prevent further prejudice. The emphasis, my Lord, here is that notwithstanding the fact that one has been committed to the High Court subsequent to the expiry of the mandatory period of 180 days, is not a preclusionary bar to being admitted to bail. My Lord, the case of Kizza Besigye, which is also on record there, Kizza Besigye, my Lord, on page 4, that decision, which is criminal misdemeanors application number 133 of 2025, which my learned friend made reference to, but mine specifically is about the spirit of Article 23. On page 4, Justice Mwata had this to say. He was quoting with approval the ratio disciplinary in Sabuharia Matia versus Uganda, which is cited there on page 4. He said the court emphasized that the High Court must protect its ability to function as a forum of justice and not an agent of oppression, particularly in cases where a prolonged decision, rather detention, the court emphasized that the High Court must protect its liberty if I read again, the court emphasized that the High Court must protect its ability to function as a forum of justice and not as an agent of oppression, particularly in cases where prolonged detention without trial continues or constitutes an abuse of court process. My Lord, in this particular case, the accused persons have been on remand as of today, have been on remand for 263 days. As of today, they have been at Uzira, maximum prison, which is a remand prison. Uzira maximum prison, which is a remand prison, for 263 days. My Lord, I will refer you again to the decision of Colonel Dr. Kizza Besigye. This is Colonel Besigye versus Uganda. It's bail application number 228 of 2005. (228 and 229, my Lord). of 2005. There were two bail applications. They are here in our bank of my lord. On page 6, Justice Ogola, the principal judge then, emphasized the role of court in protecting the right to liberty. And indeed, he explained the sanctity of this right in the following terms. I have taken into consideration the fundamental importance of bail as the judicial instrument for ensuring the liberty of the individual. In this regard, the quest for bail is a quest for liberty. The right to the liberty of the individual is next only to the individual's right to life itself. You need to underline that. The right to liberty of the individual is next only to the individual's right to life. After the right to life, the next one is right to liberty. And that higher. Liberty is as crucial in a free and democratic society as breath is to life. Liberty is as crucial in a free and democratic society as breath is to life. Liberty is so precious a commodity that during the American struggle for independence, some 300 years ago, one of the American independence protagonists, I believe it was Thomas Paine, summed up the situation with the following eloquent and immortal declaration. A declaration not of suicide and despair, but of defiance and triumph. That is quite instructive, my lord. A declaration of not suicide and despair, but of defiance and triumph. Give me liberty or give me death. That sums it up for us. These are not my words, Justice Ogola. Liberty is the very essence of freedom and democracy. Now, looms large. The liberty of one is the liberty of all. The liberty of anyone must never be curtailed lightly, wantonly, or even worse, arbitrarily. Article 23, clause 6. This is the provision we are emphasizing. Article 23, clause 6 of the Constitution grants a person who is deprived of his or her liberty the right to apply the competent court of law for the grant of bail. I want to sum up what Justice Ogola said by reading the following line. The courts from which such a person seeks refuge and solace should be extremely wary of sending such a person away empty-handed, except, of course, for good cause. Ours are courts of justice. Ours is the duty and privilege, jealous and courageous, guard and defend the rights of all, in spite of all. God just the right of all, in spite of all. My Lord, is a very, very instructive word from Justice Ogola, this project. They sum up the significance and sanctity of the right, which is next. My Lord, which is the reason the framers of our Constitution made that right mandatory when one has spent 108 days of the month. That's the reason we made it. And my Lord, I want to emphasize the submission of my young friend here in Panga. Initially, the constitutional order had been provided for 360 days. Under the 1995 Constitution, it was 360 days. As a nation, we consider that to be irrational and inimical to enjoyment of the right liberty which is granted by court. It formed the amendment of 2005 to reduce it to 180 days. And now, the state is advancing such a flimsy reasons to derogate from that sacred provision of the Constitution. This court should not be used as a forum of operation, as a sacred branch justice. This is not a forum of operation. My Lord, I will recite the last authority on that. Again, Dr. Kizza Besigye, constitutional reference, 2005-2006. My Lord, on page 8 of that decision, the Constitutional Court unequivocally proclaimed on page 8 that we turn to Article 26, Clause 6, B and C. We accept the general position as stated by both the Council that the court has no discretion to grant or not to grant bail after the accused has shown that he or she has been on remand in the custody for 60 days before trial or 180 days before committal to the High Court. As regards Article 23, 6C, this is specific now in this particular case, where the accused person has been in custody for 180 days on an offense trial by High Court only, and has not been committed to the High Court for trial, that person shall be released on bail on reasonable conditions. Like Article 23(6), the court has no discretion to refuse to grant bail to such a person. In both Article 26(6)(b) and C, the court has discretion to determine the conditions for bail. My Lord, this is binding on this honorable court. This is a constitutional court decision. I don't need to emphasize the point that it is binding. What I need to emphasize again, the right to bail, the sanctity of liberty, as it was explained in that decision on page 11, where the burden is cast on you to balance the two imperatives. There are two imperatives, and these are captured here. The needs of society to be protected from lawlessness, and the considerations which flow from people being remanded in prison custody, which adversely affects their welfare and that of their families, and not least the effect on prison remand conditions if large numbers of unconvicted people are remanded in custody. My Lord, these are some of the imperatives. And finally, on page 12, this is what the Constitutional Court said. Remanding a person in custody is a judicial act, and as such, the court should be summoned its judicial mind to bear on the matter before depriving the applicant of their liberty. My Lord, I think those authorities are enough. But probably I also cite one of the FHRI, the last one now, because it was also cited by my friend here, Mr. Mpanga. I'll go to page 36, still on the significance of this right to liberty. The institution of bail is meant to protect and guarantee the fundamental rights of the individual to liberty, the presumption of innocence and the due process of the law on the one hand, and the societal interests on the other. The most important condition is that the accused will return up to his trial and will not interfere in any of the evidence. My Lord, it's about again putting emphasis on the right to liberty. So I think there is no doubt that this right is one of those most sacrosanct rights guaranteed under the Constitution. Now, my Lord, with the authorities I have cited of the Superior Court, which are binding on this Honorable Court, but also those which you have cited, like the one of Justice Moata and Justice Lamu, granting mandatory bail even after committal, are equally binding on this Honorable Court, my Lord. We would like to cite the the case of Semogere and others versus the Attorney General, Constitutional Appeal number 1 of 2002, on the question of doctrine of precedent, where the Supreme Court, my Lord, stated that as regards, of course, they made reference to decisions of Superior Court being binding on lower courts. I don't need to waste your time on that, my Lord. But when talking about decisions of your brother and sister justices of the High Court, judges of the High Court, they say, as regards its own decisions, the decisions of this court, it would normally be bound by them, except under the following circumstances. One, that the court is entitled and bound to decide which of the two conflicting decisions of its own it will follow. If there are two conflicting decisions, there you have discretion, the discretion to choose which one to follow. You may not necessarily be bound. But in this particular case, my Lord, the decisions are consistent. That even after remand and another committal, mandatory bail still stands. So that is first proviso is not applicable. The second proviso is that if court is satisfied that the decision was given by impunity, it's our submission, my Lord, that going by the doctrine of stare basis, the decisions we have cited are not by impunity, because they formed the gist of the proclamations made by the court in those particular decisions. I want to sum up this point of civil liberties, my Lord, by again speaking to the spirit of the practice guidelines. My Lord, the practice guidelines on bail the constitutional bail guidelines for courts of judicature, practice directions 2022. My Lord, particularly Regulation 10, which talks about mandatory bail for offences triable only by the High Court. Clause 2, or rather paragraph 2 of this Regulation 10, in the case of a person who has been on remand for 180 days in accordance with Article 23, Clause 6C of the Constitution, the Magistrates Court shall immediately refer the file to the High Court. My Lord, I want to draw parallels with the sick person qualified as an ambulance. If the file of Dr. Besigye and Obed will collect before the magistrate in Nakawa who handled the free trial processes was a human being, if that file was a human being, on the 29th, on the 19th day of May, they would have put that person in an ambulance to the referral hospital. To the referral, because the regulation provides shall immediately, upon expiry of that 180 days, immediately forward the file. And in the same spirit, my Lord, Regulation 8, time for disposal of the bail application in the High Court. The court shall consider disposal of an application for bail expeditiously, and in any case, within 30 days from receipt of the application. See, one shall be determined expeditiously, but in any case, if court is constrained by some supervening factors, not exceeding 30 days, my friend. All this is meant to emphasize the point that the law accords the right to liberty, the sanctity of the service. And it is the reason, my Lord, speaking to the spirit of the law, that under Section 76 of the MCA, Parliament directed the magistrate handling such a matter that once 180 days have lapsed, don't do anything else. The next course of action is consideration of mandatory bail. My Lord, for the accused person to continue being on remand up to the present, the 263 days, when all the laws we have cited, the Constitution, the Acts of Parliament, the practice guidelines, the authorities cited, all speak to the urgency of matters relating to the right to mandatory bail. In itself, my Lord, is a negation of that spirit. To see to it that they are still on remand. And as we speak, my Lord, no arrangements have been made for the trial. The state is not talking about the trial at all. And actually, for the record, my Lord, there is still a debate. Was the committee made to this division or to the ICT? That's where we are looking for a forum where the trial will be conducted from, to the prejudice and detriment of the applicants, and particularly the sanctity of their rights. My Lord, the last issue I wanted to speak about the argument that the charges before the Nakawa Magistrate Court are different from the charges that were preferred against the accused persons at the General Court Martial. That's another subject. With the travesty of the IC order, my Lord, if that argument is accepted by this one. From the facts which are not disputed, as highlighted by Mr. Mpanga via my land friend, the state is the one that actually kidnapped, picked Dr. Besigye and Besigye from Kenya on the 16th day of November. That is the very state, Uganda, which preferred the charges against Obedi Lutale and Dr. Besigye, Uganda, in the general court martial. It's the same state, Uganda, that moved the then defunct general court martial to remand the accused persons. When you look at the chain of events, my lord, after the intervention of the Supreme Court in the matter, because it's well documented, it is the same state that preferred those charges relating to the same file before the general court martial. On the same set of facts which are before you. Same set of facts, same allegations. Even the particulars are all the same. Even the countries we are talking about, Switzerland, Greece, Kenya, no mention of anything different from what was reported there. So to purport to treat those as separate charges, my lord, is stretching this matter to the So invite you, my lord, to dismiss that argument in the point of the results. Finally, my lord, I've addressed you on the mischief that the Constituent Assembly attempted have, keeping people, accused persons on remand indefinitely. My lord, this honorable court should acquiesce in that, should it be treated as an accomplice in the persecution of the Africans. We pray that you give this, but you make them to mandate the grave. My lord, my colleagues will address you on the issue of the sureties, because yes, Stampang has already cited the decision of your dear sister, I mean your land sister, my lord, your land sister, Justice Comfort, on the issue of the sureties, which has not been set aside in any way overturned. My lord, we shall continue addressing you the same, because we have no sureties.
You say you want the same today, or you want to adopt the other prejudice?
We are adopting those other ones, but making an addition. We do so.
I'll continue. The brief, the honest brief of the Africans, that they be admitted to mandatory detention. I will add a few clarifications. One such clarification is to clarify the nature of arrest. On 16th of November of 2024, what happened on 16th of November 2024, what happened in Nairobi, Kenya. The applicants who are waiting for a simple launch of Honorable Karwa Martha was not a mere or ordinary arrest. was an abduction. So before you, Your Lordship, are victims of abduction. That is contained in paragraph 5 of the affidavit of the first Africa in support of the mandatory paragraph 5. Before they were remanded and following their abduction from the foreign capital, they were subjected to incommunicado military detention. They were subjected to incommunicado military detention at the matching military balance. That's for 4 days, 4 clear days. And you are in between 16th of November to 20th of November. The same year, 2024. Before we go very far, this has legal implications because, first of all, incommunicado detention is unconstitutional and is a violation of personal liberty. That Article 23 6 protects. But even more poignantly, according to our law, and specifically the second schedule of the 2012 Prohibition and Prevention of Torture Act, Item 2, subparagraph 3, incommunicado detention is a form of mental or psychological torture. So, yet again, before you, Your Lordship, are 2 victims of psychological torture visited on them by Uganda People's Defense Forces. Torture is a crime, and in this instance, the scene of crime is matching the military barracks, Your Lordship. After enduring torture and abduction, as I have elaborated above, on the 20th of November 2024, the applicants before you were arraigned. They were arraigned before a Cameroon military tribunal. They were arraigned for a Cameroon military tribunal. That military tribunal was at Matching. It is like 1 kilometer away from the scene of crime. They have never been free since then. They have never been free. That's why they are coming before you. Those facts I must emphasize are not mine. They are contained in paragraphs 4 and 5. Signed statement of the first applicant, paragraphs 4 and 5. You're under the duty of releasing the applicants from an account of mandatory bail rests primarily in the court.
My Lord, just a moment. I think this is just overwhelming court review. My colleague is simply overwhelming court review.
So before I was rudely interrupted by the I was following the thought. The fact that even if the applicant has not applied, even if the applicant has actually not applied, that's not a prerequisite for mandatory bail. The application for mandatory bail is not a prerequisite for mandatory bail. The prerequisite for mandatory bail is the effluxion. The effluxion of 180 days for capital offenses. It's not an application. It behoves the judiciary, but specifically the trial magistrate. One, to count the days, to be aware of how many days they choose it before the person has spent remand. And as soon as they clock 180 days in the case of capital offenses, pursuant to section 76 that has already been alluded to from the Magistrates Court Act, the magistrate can simply release. It's as simple as that, although some people want to complicate it. Now, your Lordship, if the magistrate does not want to release the applicant following the parent law, there is subsidiary law called the bail guidelines. Because for me, there should be no debate between the conflict between parent law and subsidiary. But in case the magistrate has any doubts about what to do, they should follow regulations 10 for the bail guidelines and immediately refer the file to the High Court. And once that file is referred, again in sub-regulation 11, the registrar of the High Court or the criminal court which the matters are referred is obliged, it's not requested, is obliged by the bail guidelines to shield them, and of course mindful that the court should resolve the matter within 30 days. The reason the magistrate is assumed to know the remand days because every remand, your Lordship, happens under the remand warrant. Every remand happens under the remand warrant of a judicial officer and before committal specifically of the magistrate. Your Lordship, the magistrate cannot feign ignorance that somehow I did not know that the applicant before me, the accuser before me, has not spent has not spent 180 days, because every mention they have to be aware of how many days that the accused person has spent on remand before further forbidding them on remand. Your Honor, it is the argument of the state that they are about chance. The reason they are objecting, one of the reasons they are objecting to the mandatory bail, which is an unconstitutional reason, because it's chance, press conferences, and yes, chance and press conferences. I want to say that those are constitutionally protected rights under Article 29. And a thorough reading of Clause 1, Article 29, would preclude the state from citing it as a ground for objection. The related objection, Your Lordship, is that it is in paragraph 29, I think, of the reply, the state's reply, and it says that the accused is of a high profile, paragraph 29 of the affidavit of Undape proceeding. The reason is that the accused are high profile, influential, and command a big following. Your Lordship, few statements are astounding as this in the journey of the legal profession. So you are being invited on record in writing, Your Lordship, that you stop the bail, the liberty of the accused, simply because they are high profile, influential in society, and command a big following, and they have the audacity of including this in the sworn testimony and filing it on the record of the High Court. Your Lordship, high profile popularity is not a ground for denial of liberty, even if you are not mandatory bail. I think it is irregular for the state to be envious of the accused. The point of liberty has been first clarified, but one of the fundamental points of mandatory bail is actually to stop trial without detention. Detention without trial. And these are not my own words, these are the words of the Constitution. And the Constitution adopts them in Article 43. The twin purpose is prevention of political persecution. Again, Article 43 succinctly and expressly outlines that. It is a factual reality that the accused are being politically persecuted. Although it goes without saying, the accused have taken the problem to outline it in paragraph 3, rather paragraph 13, paragraph 13 of their affidavit. Paragraph 13 of their affidavit talks very clearly about the political persecution that the accused have had to endure. I will end by clarifying the issue of mandatory bail, especially the fact that there was a transfer of charges. This followed a Supreme Court decision. And unless the state is saying that it defied the Supreme Court decision, and it did not transfer the charges of course, the facts will betray them. Your Lordship, what changed was only the courts. The fact of remand itself had never changed. Howsoever framed the charges that were in the court martial are still here by order of the Constitutional Court. The idea is that the facts are the same, have not changed, and the law is on the principle of equality and double jeopardy does not allow, it's not even at the extent and now introduce new facts. The state, the law on the constitution on fair hearing does not allow twisting facts so that on the basis of the same fact you bring a multiple charges, you keep tinkering with the nature, the legal nature of charges while you're using the same fact. That is not allowed. And in any event, it would have been prohibited by the order, express order of the Constitutional Court. So the accused or the applicants have been remanded by 4 courts. The first court to remand them was the Kangaroo Military Tribunal, 20th of November 2024. Following the Supreme Court judgment, the applicants made an application to the High Court Civil Division for habeas corpus. They argued it. And on one of the questions they argued it, I was there, it was here. Yes, so they were remanded by that court. Even before their ruling on habeas corpus. Then they were remanded by magistrates court in Nakawa, and then they were remanded by the criminal court, the criminal division here. That is just okay. Most of that I will leave the floor to my colleagues.
I'm trying to say that I'm going with issue. Yes, rotating on the same grounds. Kindly think, let us restrict on the points that have not been raised by another party.
Marshal Price, my Lord. Luyimbazi Nalukola. My Lord, I will not consume a lot of time, but rather only 2 minutes. My Lord, you have a simple task today, only to implement a constitutional commandment. Which is provided for under Article 23, 6C. My Lord, the provision is in respect of actual bail. Our application, my Lord, is not for a discretionary bail. And indeed, my Lord, the bail we are seeking, today the applicants are not here for a right to apply for bail. but rather to receive a bail, my Lord. That provision was deliberate and intentional by the framers of the Constitution of 1995. Deliberate and intentional. It was premised on, among others, the oppressive and imprisonment without trial which was characterized, which characterized our political history, my Lord. My Lord, denial of the right to a mandatory bail by the applicants now before you will be so detrimental to the values and wishes the framers of the 1995 Constitution intended to achieve, my Lord. My Lord, I invite you, my Lord, to stand tall over the unsubstantiated allegations advanced by the state. To persuade you not to grant the application, my Lord. My Lord, I beg to rest.
I have only one or two things to say. Firstly, to reject the proposition in the paragraph 17 of the respondent's affidavit that the applicants have only spent 167 days. We just want to emphasize that there is only one state, and that is the state of Uganda. And
Says they have been, the citizens that they have been remanded for only
167 days. They deliberately refused to account for the period between 20th of November 2024 and 20th February 2025. They admit that period in their affidavit, but they refuse to account for it. And I say there's only one state, and it is the state of Uganda that was holding them with that period, which is 90 days. So if you add 90 days to their admitted 167 days, that's a whopping 257. But if we count up to today, it's 263, as indicated by my colleague, Elias Kwame. You have the final word. Count the dates from actually the dates of arrest. The date of arrest or abduction in Kenya by Ugandan military, including the Kenyan military. That matter is subject of a case in the court of Kenya. the other point, you have been told that the applicant, the first applicant, has been in many cases. What the prosecution is saying, this is in paragraph 18. They even cite an existing case, which is case number 624 of 2023. Kindly note, my lord, they are not talking of convictions. They are talking of prosecutions they have mounted against him without securing a single conviction. Prosecutions designed to keep the first applicant in custody, just like in this case. You can only put previous antecedents when a court has pronounced itself and there is a conviction. For the case that is pending before the Nakawa Court, 624 of 2023 criminal case, the prosecution cannot have their case admitted. Why have they not concluded the prosecution since 2023? You come to cite a case where again you are guilty of laches. The associates who are accused of singing are not named, nor are tapes of what he finds, the music that he finds not good, not so melodious to his ears. So it's a mere allegation. And what if others have sung? Are these two applicants going to be punished because others have still sung? We are asking the court to ignore. Finally, I just want to remind the court that Article 126 of the Ugandan Constitution, which we happily borrowed from in Kenya, clearly states that the judicial authority comes from the people of Uganda. It is to be exercised in accordance with the Constitution, which has been amply cited to you by my worthy colleagues who have elaborated on the law applicable in this case. The Constitution also clearly states that it is the supreme law of the land. So I'm most respectfully telling the court that it has no option but to grant bail on terms, such terms that are reasonable, especially because the prosecution, as per the affidavits, have no compelling reason why the court should not. Before I hand over to my colleague, Mr. Karibara, to talk about the sureties, I want to seek the court's indulgence. I came a few minutes late because it came on a day flight. I'm also seeking to leave now because I'm on a flight to Nairobi at 4:30 because I have a funeral to attend tomorrow. So I seek the court's indulgence. I'll be leaving, but I'm comfortable that I'm leaving to a team that has performed so well and continues to explain what
My Lord, my is simple task to introduce the sureties to the court. My Lord, in respect of the first applicant. We have lined up a total of 7 sureties. And on 4 of those 7 sureties namely the Honorable Ibrahim
Seven for each. Seem to be a substantive. The minimum of 4.
So that's the debate I
For
was
each.
the debate I was having with my colleagues here.
What is your?
Because the first 4 that I was saying, I was naming alone were sureties, Judicial 113.